trial by ordeal and combat were officially abolished in 1215 by the Pope, marking a shift towards more rational legal processes. Norman and later medieval law enforcement. After 1066, the Normans largely maintained the Anglo-Saxon system of law enforcement, including tithings, the hue and cry, and the court system. However, they also introduced significant changes that began a shift towards greater governmental responsibility for law enforcement. This blend of continuity and change shaped the evolving justice system. One notable Norman innovation was trial by combat, reflecting the more military nature of their society. In this method, two disputing parties would fight, often until one was killed or surrendered, with the outcome seen as divine judgment. Additionally, foresters were introduced to police the royal forests, enforcing the strict forest laws. These officials were often feared due to their harsh treatment of suspects, highlighting the new, more centralized control over land and resources. As towns grew in the 13th and 14th centuries, crime rates increased, prompting greater involvement from authorities. While communities still played a role, new official positions emerged. Parish constables, nominated by the community, became responsible for leading the chase after a hue and cry and maintaining peace. These were unpaid positions, held for a year, demonstrating a civic duty. The later medieval period also saw the expansion of government-appointed officials. Knights were appointed as keepers of the peace from 1195, a system extended by Edward III in 1327 to all areas. By 1361, these evolved into justices of the peace, JPs, who gained the power to hear minor crimes in local courts 4 times a year. The role of the sheriff also expanded, becoming responsible for tracking down criminals when the hue and cry failed, and allowed to form a posse of locals to assist. Trial by ordeal and combat were officially abolished in 1215 by the Pope, marking a shift towards more rational legal processes.